Hey listener, tonight we're going to dive into the juicy topic of lawyer-client sexual relationships from an ethical perspective. Is it okay for a lawyer to fall in love with his client? Can a person honestly represent their partner? While these dalliances are problematic from a professional ethical perspective, the rules of professional conduct provide a framework for lawyers to manage conflicts of interests that arise as a result. The term conflict of interest is defined for us in section 1.1-1 of the Rules of Professional Conduct. Conflict of interest means the existence of a substantial risk that a lawyer's loyalty to or representation of a client would be materially and adversely affected by the lawyer's own interest or the lawyer's duties to another client, a former client, or a third person. The risk must be more than a mere possibility. There must be a genuine, serious risk to the duty of loyalty or to client representation arising from the retainer. The official commentary adds that substantial risk means that the risk is 1, significant, and 2, plausible, even if it is not certain or even probable that the material adverse risk will occur. The term thus describes the likelihood of impairment as opposed to its nature or severity of the impairment. There must be more than a mere possibility that the impairment will occur, except as otherwise provided in Rule 3.4-2, which we'll see in a bit. It's for the client, not the lawyer, to decide whether to accept this risk. Whenever a lawyer takes on a new mandate or the circumstances between that lawyer and their existing client have changed, they have to take steps to evaluate whether a conflict of interest exists by assessing the following criteria. First, the duties owed to the client or prospective client. For example, the duties of confidentiality, the duty of honesty and candor, the duty of objectivity, and the duty of loyalty owed to any client. Next, they have to consider any duties owed to other clients, former clients, or third persons. And lastly, a lawyer should take into account any outside personal or financial interests that may compete with the above duties. Use your judgment when making your assessment. Remember, the Law Society defines a substantial risk of impairment as being a significant and plausible risk. So if there is a change that a situation will give rise to a conflict, you're on questionable ground and you should govern yourself accordingly. The rules surrounding how to manage a conflict of interest are outlined in section 3.4 of the Rules of Professional Conduct. These rules are short and sweet, so listen carefully while I read them together, which I think helps understand. 3.4-1. A lawyer shall not act or continue to act for a client where there is a conflict of interest except as permitted under the rules in this section. A lawyer shall not represent a client in a matter when there's a conflict of interest unless there is consent, which must be fully informed and voluntary after disclosure, from all affected clients, and the lawyer reasonably believes that he or she is able to represent each client without having a material adverse effect upon the representation of or loyalty to the other client. This obligation, being obligation 3.4-2, flows from Rule 3.2-2, which is a lawyer's duty of honesty and candor. Put plainly, these rules together state that a lawyer is prohibited from acting or continuing to act for a client where there's a conflict of interest unless the lawyer very clearly and openly meets the two following criteria. 1, the lawyer in conflict believes with reason that they can fulfill their duty to provide objective and disinterested advice to the client, notwithstanding the conflict. And 2, that the client is fully informed and consents voluntarily to continue being represented by that lawyer despite the conflict. You might be thinking what I was thinking when I read the rules, which is, so, does this mean I can represent my friends, my family, my lovers, my neighbors? I'm not sure. So, a lawyer is not precluded from acting for a friend or relative, but the existing relationship does run the risk of impairing that lawyer's ability to perform their duties to the client, giving rise to a conflict of interest pursuant to the rules set out in sections 1 and 3.4 that I just read. If your ability to fulfill your obligations as a lawyer to them is impaired by your personal history or situation, then no, you cannot represent that client. In the instance where the lawyer cannot fulfill their duty to provide objective and disinterested advice because of personal feelings, attachments, history, or other personal implications, that lawyer should either decline to act or cease acting for the client in question. Next, how about if you're convinced that your ability to fulfill all of your obligations as a lawyer to your client is not impaired? Then, sure, but you have to act with voluntary consent. If the lawyer thinks, in good faith, that they can make good on their duty to remain loyal, impartial, and objective, they can continue to act for the client with whom they have a conflict of interest as long as the client has been fully informed of the risks of proceeding and that lawyer has given clear and voluntary consent. Remember, It's for the client, not the lawyer, to decide whether or not to accept the risk of impairment. It's worth noting here that a personal conflict of interest is not imputed to other members of a law firm. So when a lawyer at a firm finds themselves in such a situation, it's totally permissible and okay for them to transfer the file to another lawyer in the office. This could be considered a pretty positive outcome in a lot of cases. It's time to dig into the nitty-gritty, nasty, dirty, cautionary tale that is the Law Society of Upper Canada versus Hunter, which I'm calling a cautionary tale for lusty lawyers and how not to manage conflicts of interest in sexual and romantic relationships with clients. So, XY, who I'm going to call Sarah because it's just easier to follow if she's called Sarah than XY, is the client and complainant who was hired by Mr. Hunter, who I'm going to call by his first name George too, to represent her in a family law matter in the fall of 2000. The matter in question related to emotionally distressing family matters involving the custody of her young daughter and her alcoholic ex-husband. So these were not run-of-the-mill ordinary things, and they were emotionally distressing for the client. George worked in the file with Sarah up until 2003. Until that point, their relationship was entirely professional and above board. However, in the spring of 2003, their relationship started to heat up, and George invited Sarah to several dinners and to a hockey game, and after one dinner one night, the two engaged in sexual relations for the first time. George and Sarah kept on their sexual romantic relationship for 2.5 years while George continued to represent her, and it's clear in the circumstances that Sarah was emotionally vulnerable over the course of the relationship. November 2005, after George and Sarah had been seeing each other for about 2.5 years, George asked Sarah to meet him at a lounge near her office where he presented her with a copy of then Section 2.04 of the Rules of Professional Conduct, which is now 3.4, which we discussed above. He had her initial each and every page and then sign an acknowledgement that she had read it. It's unclear whether George advised Sarah to seek outside counsel before signing the documents, but obviously in the context, she didn't have a meaningful opportunity to review. So once Sarah signed all the paperwork at this one meeting, George admitted to her that he had had intimate affairs with 2 other women over the course of their relationship, and she was obviously heartbroken. Over the course of the next few weeks, George chased Sarah for additional information and to get her to confirm his version of events about the nature of their relationship. And the last straw was that George showed up at Sarah's house unannounced and uninvited at 9:30 p.m. to ask her to speak with his counsel and to explain to his law firm the nature of their relationship. Needless to say, the entire debacle caused extreme emotional stress to poor Sarah. Eventually, the issue made its way to the Law Society, and George was sanctioned for professional misconduct and had his license suspended for 60 days, and he was forced to pay a $2,500 fine. So, now that we're all experts on personal conflicts of interest, let's go back to the beginning. George had an obligation from the moment his relationship devolved from professional to romantic to make the following assessment. He has to consider the criteria we discussed before. First, what are the duties that George owes to the client? Well, obviously, a duty of loyalty, a duty of care, a duty of honesty. And does he have any outside personal interest that may compete with the above duty? The answer being yes. So, the crux of the misconduct in this case is 1, the conflict of interest arising out of the intimate relationship between Sarah and George. 2, George's failure to appropriately recognize and address the issues surrounding that conflict, and 3, his completely inexcusable behavior at the November 2005 meeting and thereafter to attempt to rectify the situation by pressuring Sarah to confirm his position. George had a duty to provide objective, disinterested, professional advice to Sarah as her attorney. The romantic relationship had a significant potential of jeopardizing his ability to provide such advice. It also had a significant potential of inhibiting Sarah from challenging or even questioning the advice she was being given. The fact that Sarah viewed the relationship as serious and committed reinforces that potential danger. This is a really sad story for Sarah. As mentioned, the rules don't create an absolute prohibition against initiating or continuing sexual relationships with clients. However, and this is a big however, it can fairly be said that such a relationship with a client, at the absolute very least, raises serious questions about whether the lawyer is thereby placed in a conflict of interest or is otherwise jeopardizing his relationship with the client. So, given the obvious existence of a conflict of interest, George was obligated, pursuant to the relevant section of the rules, to discuss with his client at the outset of their relationship whether he should continue to act on her behalf. George really should have referred, at a minimum, to the circumstances that created the conflict of interest and the dangers and risks associated with that conflict for his client in her interest.
Think of me for a moment, not as an attorney, but as a friend.
Does that mean you won't be charging us for the hour?
So, to wrap this up, it's crucial to the maintenance of the profession that clients have access to honest, balanced, and objective representation, free of the complications of personal conflicts. Disasters like the one explored in the Hunter case can be easily avoided by giving full disclosure, that is, if your judgment isn't impaired, and if it is, passing the case on to a trusted colleague. The bottom line is that if the conflict doesn't pass the smell test, it's because it stinks.